This is Syndication Attorney Field Notes. I'm Tilden Muschetti, and today's field note is about LLC versus LP entity choice in a Regulation D syndication and how that choice affects sponsor liability. A sponsor sits across from me and asks a question I hear all the time. Should the fund be an LLC or an LP? And usually the reason they are asking is the wrong reason. They're thinking about filing fees or which one their buddy used. That is not the decision that matters. Here is the thing to understand. This is not a filing fee decision. It is an architectural one. The right question is not which one is cheaper. The right question is who is writing the checks and where does the liability land when something goes wrong? So let me give you the short answer first. For most raises funded by individual accredited investors, high net worth people, a manager-managed LLC is usually the simpler and cleaner container. One entity does the protective work for everyone. When you start bringing in institutional capital, an LP may be expected or even required, but an LP has to be built the right way. And that means putting a separate LLC in the general partner seat instead of you signing as a human general partner. That's the dual entity structure. And one more thing before we go deeper. Your entity choice does not dictate your Regulation D exemption. Whether you are doing a private placement under Rule 506B or Rule 506C, that is a separate layer of law. So don't tangle the two together. Now, why do smart sponsors still get this wrong? Mostly because the content they find online about LLC versus LP is written for someone opening a coffee shop. It's about cheap state filings. That advice does not apply to a securities offering holding millions of dollars of passive investor money. The other reason is the word limited partnership. It sounds protective, like everyone is covered, and the sponsor assumes that if it's a limited partnership, they must be limited too. That's the mistake. So let me draw the distinction because this is the part that matters most. In a manager-managed LLC, you have two roles inside one entity. You, the sponsor, are the manager. You run the deal. Your investors are non-voting members. They supply the capital and stay passive, and both groups get liability protection from that single entity. A tenant slips and sues, the claim runs into the LLC, and the shield generally protects everyone's personal assets, including yours. An LP splits the world differently. Limited partners, the passive investors, are fully protected. Their risk is capped at what they put in, but the general partner is not protected. Under partnership law, a general partner in an LP carries personal exposure for the debts and obligations of the partnership. So picture this. John Doe signs the partnership agreement as the general partner of Main Street Fund LP. There is no entity between John and the fund's obligations. John is the general partner. If the fund faces a judgment that runs past its insurance, creditors can reach past the fund and get to John's personal assets, his home, his savings. That's what I call the naked GP trap. The fix is simple to describe. You never let a human sit in the general partner seat. You form a separate LLC whose only job is to be the general partner. John manages that GP LLC. The GP LLC serves as the general partner of the fund. Now there's a layer of protection between the fund's liabilities and John personally. Let me make this concrete with two raises. Raise number one, a $5 million value-add multifamily deal funded by individual accredited investors writing personal checks. That fits cleanly in a manager-managed LLC. One entity, one operating agreement, clean protection. You don't need anything fancier. Raise number two comes a year later. Now you're building an investment fund, and a family office wants it, and they tell you they'll invest, but only through a limited partnership structure. For their tax and regulatory reasons, that's a condition. So now you need an LP. And the safe way to build it is a fund LP with a separate sponsor GP LLC acting as the general partner. Same sponsor, but structured so you're not standing there as a naked human GP. Now, a few things not to assume. Don't assume the entity decides your exemption. State entity law and federal securities exemptions are two different layers. An LLC or an LP can each run under 506B or 506C. Don't assume every institutional investor wants the exact same LP structure. The tax and regulatory reasons vary by investor, and those are fact-specific questions. That's a conversation for a qualified CPA, not a rule of thumb from a podcast. And don't assume the entity protection is absolute. You still need separateness, clean records, insurance, and good conduct, even in a flexible state. You cannot contract your way out of acting in good faith. So here's the field note to carry with you. Match the legal container to the capital source before you draft the PPM and the subscription agreements. Those documents get built around the entity's fiduciary framework. Switching from an LLC to an LP halfway through is not a small edit, it's a rebuild. So architect before you draft. For a retail syndication, that often points to a manager-managed LLC. For an institutional LP structure, solve the general partner liability problem with a GP LLC from the start. Get that container right, and everything downstream has a stable place to sit. The longer written version is in the show notes. I'm Tilden Moschetti, and this has been Syndication Attorney Field Notes.